Yes, good morning, Your Honor. DJ Fredericks with the firm Anderson, Givens & Fredericks here on behalf of the appellant, Wanda v. DiPaola, Stephen Rink, General Partnership. We're here seeking the reversal of a final summary judgment which consolidated two summary judgments entered in the lower case. Both summary judgments have to do with two separate distinct issues.
Would you like to reserve any of your time?
Yes, Your Honor, please. 5 minutes.
5 minutes?
For
Okay.
rebuttal. Thank you. The first summary judgment deals with amendments to a declaration of a condominium. And the history of this case, as well as the previous case in 2004, is pertinent to both the first and second issues that we're dealing with today, Your Honor. The condominium unit that we're dealing with is Unit 4-4. And that condominium unit is a donut. And in the middle of that donut is a chase. And in that chase is where the HVAC system and other common elements of the association reside. That's where they sit. Those common elements are the responsibility of the association. In a 2004 case, the association tried to shift the responsibility of the HVAC system to the unit owners. That was successfully challenged on multiple fronts and multiple times by my client. There's a summary judgment in 2006 invalidating amendments which are almost identical to the ones we're dealing with now. There was a 2009 judgment which allowed for injunctive relief to order the association to fix the HVAC system, and there were supplemental relief in 2012 for damages related to the proper operation and maintenance of the HVAC system. The reason why that's pertinent now, Your Honor, is because in 2011 the association sought to amend the declaration again to, shift the responsibility of the HVAC system to the owners. We sought to challenge that to declaratory relief, and also in count 2 regarding the constitutional argument related to the statute which was utilized by the association to do that amendment now.
Just as a point of procedure, at any time, I didn't catch this in the record, did any time in this constitutional challenge did anyone provide notice to the AG?
Yes, Your Honor.
That did happen? Okay.
Yes, Your Honor.
They just didn't put a dog in the fight?
The lower court did, and also myself, I did as well for the appellate procedure as well. So yes, Your Honor, they were notified. The amendments shifted the responsibility of the HVAC to the owners, and in the case below, the point that the appellant was making and has made multiple times that the precedent has been established that the association is responsible for that HVAC system. Now, and in the lower court,
and help me out, how do you get there? Because as I read the 2004 final judgment, all it did was basically just kill that amendment and revert back to what the prior recorded instrument was, which said that the HVAC units expenses of the HVAC units were charged to the owners. As I read what happened here, what you did was you were able to successfully get rid of an amendment that imposed a positive duty that could be enforced to maintain, repair, replace, what have you, to the HVAC units, and just simply reverted back to what had originally been declared, which just said whatever the expenses are, if you incur them, it's charged to the owners. And that's a little bit different than what you're telling me it says.
When the amendments were struck down originally in the 2004 case, it was not only just the responsibility and the expenses to the owner, it's the definition of a common element. And under the statutes in Chapter 718, a common element is to be operated and maintained by the association.
Right.
So both the responsibility to maintain and the expenses, which are incorporated into the responsibility to maintain, were the reasons why that amendment was struck down.
But what the judgment did was say the operative declaration, or the operative recorded instrument that was in effect at the time before, which still had that language, expenses charged to the owners, would now be operative. That's what the final judgment said. It did not say, the final judgment that you're relying upon did not say, cost of HVAC unit now imposed upon association. It didn't say that.
That's because it was already on the association. The declaration and the statutes incorporate the declaration.
Except for the expenses of the HVAC units which were charged to the owners, which was in the prior recorded instrument.
In the prior recorded instrument, the reliance was based on the declaration that the HVAC was defined as a common element. And when it was defined as a common element, that conflicted with other portions of the declaration, but that did not shift the responsibility and expenses to my client. What it did was the association now latches on to other portions of the declaration and the interpretation, but what the previous court did was say no. The definition of a common element based on 718.103.8, I believe, and the declaration specifically stating that the HVAC system is a common element. Thus, my client cannot touch it. If there's a common element, owners are not allowed to touch or change them or do anything with them unless they are approved by the association. But for that approval, that common element needs to be maintained by the association. One of the issues that we have here is because they're shifting, again, the responsibility of that HVAC system to the owners, is that they're not only incurring additional expenses, they're incurring additional liability. Whenever a common element, like say a pipe bursts, and that pipe goes into other units, well, that becomes the association's responsibility. Now, what they're trying to do is shift a common element to my client and making it his liability for if something happens to it. To the point on the 718.110 section 14, which is what's being relied upon by the association, it discusses that a common element that services one unit or a group of units can be shifted into a limited common element. An example of a general common element would be like a roof. It serves the entire condominium unit. This one in the record reflects that the HVAC system is a water-cooled system, and that water-cooled system is through pipes, through the ground. It's a well system, and that well system serves every single HVAC system in the units, all 71 units.
But you would concede that the individual unit itself within the apartment, that is by virtue of the 2004 final judgment, that whatever, if there's a problem with the unit in the condo, that's, as it says here in 6.5 of the 1976 or 1970 declaration, the heating air conditioning units wholly within an apartment, the expense for which shall be charged to the apartment owner concerned.
That is why when we challenged this at section 4.11, Your Honor, regarding the definition of common elements in the 1970 declaration, as well as the same area in the 1996 declaration, that the common elements include all mechanical, ventilating, heating, and air conditioning equipment within or without the condominium units. You can't have a common element be the sole responsibility of a unit owner. That's based on what the Chapter 718 provides, and that is based on 718, 113, I believe, Your Honor, that the association, the maintenance of common elements is the responsibility of the association. It's defined as a common element. The unit owners cannot touch it or change it.
What do we do with this language in 6.5?
And that's what happened in the previous cases, that the courts at that point affirmed or confirmed that the common element is the association's responsibility, which actually was affirmed on appeal twice.
Except they didn't, and as we keep going around in circles. That's not what the 2004 final judgment says. It says it reverts back, it basically just strikes the amendment and goes back to the previous recorded instrument.
Okay. If it goes back to the previously recorded instrument, that does not provide that the unit owner is responsible for the common elements, though.
Not all of them, but it does say here, the heating, air conditioning units wholly within an apartment, expenses charged to the apartment owner concerned. And
that's why that was challenged at the time, as well as declaratory relief at the time, regarding the responsibility of that. There's a conflict, and that's when the statutes prevailed over this.
Okay, well then maybe the point of entry here would have been to ask for clarification with the trial court back then, which was to say, hey, listen, you've now declared the entirety of the HVAC system to be common element, but you've also said we're reverting back to this prior recorded instrument, which charges the expense of the part that's within the units to the unit owners. That's a conflict. We need clarification here. What did you mean? Well,
I think the clarification could also be argued based on what the subsequent judgment was entered in 2009. And in that 2009 judgment where we sought declaratory injunctive relief based on the judgment that you...
Injunctive relief.
Correct. And that injunctive relief was based on the original judgment saying that the responsibility is the association. All right, now, association, go fix it. And that's what the injunction said in the 2009 judgment entered by Judge Donnellan, I believe, at the time, where it says the defendant Beach Terrace has failed to refuse to take responsibility for the maintenance of the HVAC system. It defines what common elements are in that judgment, and then it subsequently says that the association is ordered to repair and replace the HVAC system, which is a clarification going forward with that original judgment 2006, 2009, supplemental relief, injunctive relief, fix the HVAC system. And that's what they base it on in the 2009 judgment. So based on those points, we were that it has been established multiple times that the HVAC responsibility is the association's responsibility. The association attempts to shift this based on the portion of the 718.110 section 14 regarding the shifting of the common element that serves only one unit to a limited common element. However, we posit that that is in conflict with 718.110.4, which provides that you cannot do that. Instead, you cannot change the appurtenance to the unit, and the appurtenance is a common element, without the vote of all the owners. There is nothing in the record that shows my client approved that. My client did not say, yes, I will take on this responsibility to maintain this HVAC system. There's nothing in the record, and they cannot show that in the record either. So that was the basis of our challenge to 718.110, and that portion is being unconstitutional because these are contract rights that my client has, and that this portion of the statute now invades those contract rights. When my client purchased the property back in 1985, the current owner, the declaration of 1970 prevailed at that time. The 1970 declaration also incorporates all the statutes at the time into that declaration. The provision that's relied upon by the association didn't exist at that point in time. The section 14 was not in effect until 2010, which is when they went forward with the new amendments. So again, we posit that is all, again, unconstitutional and invades contract rights. Now, to avoid losing points on the third and fourth counts, counts 3 and 4 were, judgment was entered in favor of the association based on res judicata. The main focus of their argument is that the parties were the same and also the damages sought were the same. However, the judgments, the 2012 judgment entered in the previous case, as well as the 2011 judgment, both clarify and specifically mention that the damages sought in the previous case were related to what is required to maintain and operate the HVAC system. How much does it cost to fix the HVAC system? The claim in the lower case, in the 2014 case, is related to negligence of the association and asbestos. Now, granted, they do cite that there were damages sought in both cases. However, what's clear is that the 2012 judgment says you don't get those because those damages aren't related to the operation and maintenance of the HVAC system, which is why in this case the damages are different. They are sought for a different cause of action. Negligence arose against the association and Mr. Dorado, and because the cause of action arose subsequent to that claim, the cause of action includes different elements. The duty breach causation, the cause of action involves different claims for damages. All those are different than what was decided in the first case. In addition, the first case it was declaratory relief and then supplemental relief. And the court at that point in time when we sought for damages regarding supplemental relief said that we don't get a jury trial. Here, in a claim for negligence, we are entitled to a jury trial. I think that's a clear distinction between the two claims in that the first one there was no jury trial. It's a different setup, different process, different claims. Here, we have a whole separate distinct claim, cause of action against the association for the negligence. In addition, Mr. Dorado was not a party to the previous case. The claim against Mr. Dorado, the appellee, is related to his personal negligence or his personal actions in breaching the trust and his fiduciary obligation to my client. And that leads into the fourth point in that the judge ruled in the final judgment that there is no personal liability that can be imposed on Mr. Dorado because there's no factual basis for it. The association just simply denied the allegations. No breach of fiduciary occurred. And the way the judgment is rendered is that they are not imposing personal liability based on the statutes that say that you can't unless there's breach of fiduciary obligation. However, I posit that the breach of fiduciary obligation relates to the breach of trust. The allegations are clear. There is part of the record that discusses in the interrogatory answers that Mr. Dorado knew certain amounts of information, should have informed the owners, including my clients, and part of that damages resulted from that. With that, Your Honor, I'd like to reserve for the 5 minutes rebuttal.
Okay.
Thank you.
My apologies. May it please the court. Elaine Walter of Boyd Richards on behalf of Beach Terrace Association Incorporated and John Gerardo. I'm using technology for the first time. Please forgive my foibles. Your Honors, I would like to point out first and foremost some things that are missing from the appellant's presentation, both in their brief and to you in their oral arguments. The first is, in 1976, there was an amendment to the Declaration of Condominium. Judge Lucas, I think you mentioned it when you were talking to the appellant. And that was that the responsibility for the HVAC and doors and windows and things like that became that of the unit owners.
Well, the portion that's within the unit.
Yes, the portions that are within the unit, not those big towers that are regular common elements, not limited common elements. That is nowhere within their presentation, either in their briefing or today. Another thing that is devoid in any of their papers or their argument is the fact that in 1996, Ms. DiPaola and Mr. Rinker sued the association about the sliding glass doors, windows, those types of things, and subject to Article 6.5, the same article that we're being sued about here, and they were found to have to pay for those themselves. So it's the exact same provision. So we're looking at, and I can tell you where that is in the record if you'd like to know, but it's sprinkled through in our papers. So we have a couple of res judicata things that I can get to, but if we start going through the counts one by one, number one, we need to look at first, we're going to look at count 2 first, not count 1 first, so count 1 of their complaint, and the summary judgment on count 1 is whether or not the amendment to 718.110 subsection 14 was constitutional or not. The Attorney General didn't weigh in on that, and the trial court found it not to be unconstitutional. The trial court found it to be nothing more than, and if I can find the right language, but found it to be nothing more than a restatement, clearing up of the law to make sure that community associations know what they can do. So the association, Beach Terrace, took that as a cue that it could then go ahead and do what it needed to do and to clear up some of this muddiness that has happened from the rulings that it's gotten recently between 6.3, Article 6.3, Article 6.5, and go ahead and amend their condo docs again to show that the HVAC units within the parametrical borders, I just learned that word, to make sure that those are the financial responsibilities of the actual unit owners. And they did so, and they did it in the way they are supposed to, according to the condo documents, by having a 75% more vote of the board than having a 75% more or more vote of the owners. And I don't know if I need to chronicle all of that. You read the briefs, but they did it in the proper way. And the court, again, the trial court again said, yep, fine, you met your burden on summary judgment. I'm granting summary judgment on count 1. So then we get to count 3, and count 3 is whether or not they're entitled to damages for negligence and damages. And the court looked at the 2004 case and looked at this case and said, well, you asked for the exact same thing. And it looked at the allegations. It looked at the request for relief. It looked at the proof that was being presented. It looked at pretty much all of the discovery that was presented. It looked at actually the damages and the numbers and what was being put towards the court, and whether they asked for it in a DEC action proceeding as part of a proceeding supplementary, or whether they asked for it in a negligence action. The court, in my opinion, looked at the substance over form over substance, and said it's the same exact thing. And the parties actually are the same parties, with Mr. Gerardo thrown in. And Mr. Gerardo, according to the case law, is considered to be part of the board. And we'll get to him in count 4. So the parties are the same, the actions are the same, the claims for relief are the same. So we are looking at a res judicata, or in the least, we're looking at collateral estoppel. So again, the court got it right. So then we get to count 4, and we get to Mr. Gerardo and whether or not he breached any fiduciary duty to the partnership. And the court looked at that, and it looked at all the evidence, and basically it found it to be a paper issue, that there was absolutely nothing that showed anything that was a breach of a fiduciary duty. The court didn't even say there was negligence there. So when all of the evidence was presented, there were allegations, but there was nothing to support those allegations. So what has happened here is we have over 20 years of litigation and a whole lot of back and forth, and hopefully a judgment that will be upheld, and that is what we would like you to do. And at this point, I'm not sure what questions that you have for me. Judge Lucas, you did mention the reversion of 6.3 back to its original, and that is what we believe happened in the 2004 case. And now what we're trying to do is use what we have, because the legislature provided it to us through 7.718.11014, and go ahead and fix our documents to clearly show through 6.3 and 6.5, mesh them together to make limited common elements with the correct language in the document. And we're doing that in the proper way because subsection 4 of 718.110 lets us do that, because our condo documents do let us do that with the vote that I described to you. Are there any questions from the court? Okay, thank you, Your Honors. We would ask that you affirm the trial court in all respects and affirm the final judgment.
Counsel, you have your full 5 minutes.
Thank you, Your Honor. Just a brief rebuttal, Your Honor. Just to address a couple things, the obligation of the association, we talked at length about the reversion back to 6.3 and how that occurred. The thing that's being, I think, ignored by the appellee is that that's not an issue anymore. Because in 2009, that judgment that said you need to fix it, and then the 2012 judgment that says, all right, this is how much it should have cost you to fix it, is taking care of both those issues, the obligation and then who is obligated to pay for it. And the 2009 case, where I mentioned before, was affirmed on appeal as far as the obligation and the responsibility to maintain and fix those things. So what is happening is that they're basically ignoring all that case. The 20 years of litigation, it doesn't matter anymore because we don't think it does, despite the fact that multiple judgments and multiple orders have been rendered against them, conflicting exactly what they're thinking it should be. As far as, on the same vein, going into Judge Roberts' orders and Judge Gallen's order, I wanted to read briefly what those state, because that's impacting the res judicata issue. In Judge Roberts' order, which is a 4-page order, specifically states that the trier of fact will determine what work is reasonably necessary and related to the defendant's obligations under the September 2009 order. And that order says to go fix the HVAC system. And determine the amount owed by defendant to plaintiff for the repair and replacement of all equipment necessary to allow for the proper functioning of the HVAC system. What did it cost to fix the HVAC system? Judge Gallen, after a substantial hearing, evidentiary hearing on the issue, eventually ruled that the association needs to pay, the appellate needs to pay the appellee needs to pay the association what the work reasonably necessary for related to the HVAC system, and actually included included statement that the certain damages sought did not have a nexus between those two issues. That nexus is what we're dealing with today. That nexus is the negligence of the association related to the asbestos, and not necessarily the replacement of the HVAC system. And with that, Your Honor, I'd request that the judgment be reversed and remanded for further proceedings, including that the vote required a full vote. My client did not do so and would seek to reverse that.
All right.
Thank you, Your Honor.
Thank you all very much.